When someone you love passes away and they owned a home in California, the questions come fast. Can we sell the house right away? Who actually has the authority to sell it? Do we need court approval for any of this? And if you're asking those questions right now, you're not alone. Almost every family I work with starts in that exact same place. Here's the truth. Selling a probate property in California follows a legal process that's designed to protect heirs, beneficiaries, and creditors. It can feel overwhelming at first, but when you understand the steps, you can help your family avoid delays, mistakes, and unnecessary expenses. That's exactly what I want to walk you through today. I'm Shanty Soerjono, a California probate and trust real estate specialist. I help families like yours navigate the probate process when a loved one's home needs to be sold. In this video, I'm going to walk you through the key steps of the California probate process as it relates to selling a house, from figuring out whether probate is even required, all the way through to distributing what's left to the family. So let's get started. The very first thing you need to figure out is whether the home actually has to go through probate at all. Not every property does. A home can avoid probate if it was transferred through certain legal arrangements. That might mean a living trust, joint tenancy with right of survivorship, a transfer on death deed that was properly completed, or another legal beneficiary arrangement. But here's the key. If the home was owned only in your loved one's name and none of those transfer methods apply, then probate is likely required. So before you do anything else, you need to find out how the home was titled and whether there's a beneficiary designation that lets it pass outside of probate. If probate is required, the next step is filing a petition for probate with the California Superior Court. This is typically filed by the person named as executor in the will, or if there's no will, by an interested person, such as a family member who stands to inherit. That petition asks the court to do a few important things: open the probate case, confirm the will if one exists, appoint a personal representative, and grant that person the authority to manage the estate's assets. Think of this as the formal starting point, the moment the court officially takes jurisdiction over your loved one's estate. Once the petition is filed and the court reviews it, the judge will appoint someone to serve as the personal representative. If your loved one named someone in their will, typically called an executor, that person is usually appointed. If there's no will, or if the named executor can't or won't serve, the court appoints someone called an administrator. Either way, the court issues official documents called letters testamentary if an executor is appointed, or letters of administration if an administrator is appointed. Those letters are incredibly important. They're the legal proof that the personal representative has the authority to act on behalf of the estate. Without them, no one has the power to do anything with the property. Now, before the home can be listed and sold, the personal representative needs to understand exactly what kind of selling authority they have. In California, probate sales generally fall into two categories under something called the Independent Administration of Estates Act, or IAEA for short. Many personal representatives receive what's called IAEA full authority, and that's a big deal because with full authority, the personal representative can usually list the property for sale, negotiate with buyers, accept an offer, and complete the sale without a court confirmation hearing. That being said, certain notices may still be required, which we'll get to in a moment. On the other hand, if the personal representative has only limited authority under IAEA, the process looks different. They generally need court approval, a confirmation hearing, and additional probate sale procedures. That takes longer and requires a lot more court involvement. So knowing which type of authority you have is absolutely critical before you move forward with a sale. Speaking of those notices, if the personal representative has authority to sell under IAEA, they may need to serve something called a Notice of Proposed Action before completing certain transactions. This notice goes out to the beneficiaries, the heirs, and any other interested parties who are entitled to receive notice under the law. The purpose is simple. It gives everyone a chance to object if they have a problem with the proposed sale. And here's the timeline you need to know. Generally speaking, interested parties have 15 days to object if the notice was delivered in person, or 20 days if it was mailed within the United States. If no valid objection comes in within that window, the sale can proceed without going back to court for confirmation. Once the authority is in place and the notices have been handled, it's time to get the property ready. And this is where the personal representative has a real responsibility to protect the estate's value. Practically speaking, that means securing the property so it's safe and protected, keeping the insurance in force, continuing the mortgage payments, paying the property taxes, maintaining utilities if they're needed, removing any hazards, cleaning and organizing the belongings, and making the repairs that are truly necessary. Here's something I want you to hear clearly. The goal here is not to improve the home unnecessarily or pour money into upgrades. The goal is to maximize the estate's value, to protect what's already there, and make the home market ready without overspending. Now, I also want to talk about the stuff inside the home, because this is something families often don't realize. Personal belongings are part of the estate too, unless they transfer separately. Furniture, jewelry, collectibles, keepsakes, all of it counts. Before anything gets removed or distributed, the personal representative should complete an inventory of what's there, protect any valuable items, and document everything carefully. And here's the part that can get families into trouble. Family members should absolutely not take furniture, jewelry, collectibles, or other items without authorization, no matter how well-meaning they are. I know it's hard, and I know everyone just wants something to remember their loved one by. But taking items too soon can cause family disputes, missing inventory items, and even legal claims against the estate. So please, work through the personal representative and follow their instructions. When the property is ready, the next step is actually listing and selling it. This is where working with a probate-experienced real estate professional makes a huge difference. The personal representative will typically work with an agent who understands the probate process to determine the market value of the home, prepare it for sale, market it effectively, negotiate offers, coordinate inspections, and work with escrow and title companies to get the sale closed. Every step of that transaction has to be handled in the best interest of the estate, not in the interest of any one family member, but the estate as a whole. That's the legal standard, and it's also just the right way to do it. Once the sale closes, here's what happens with the money. Before any of it goes to heirs or beneficiaries, the estate generally has to pay its obligations. That includes the mortgage payoff, property taxes, insurance, HOA dues, any repairs that were needed, the probate expenses, attorney fees, valid creditor claims, and taxes. The personal representative also has to keep accurate records of all of this, every dollar in and every dollar out. This is one of those steps that can feel tedious, but it's absolutely essential. The estate's debts and expenses come first, and documenting everything properly protects everyone involved. After the assets have been collected, the debts and expenses have been paid, and any required accounting has been completed, the remaining funds can finally be distributed. And that distribution goes according to your loved one's will, or if there's no will, according to California's intestate succession laws, which determine who inherits when someone passes away without a will. This is the step where the family finally sees the benefit of everything that came before it, but it only happens cleanly if the process was done right from the beginning. Before I wrap up, I want to share some of the most common mistakes I see families make, because if you can avoid these, you'll save yourself a lot of heartache. The first is selling before you have legal authority. Just being a child, a spouse, an heir, or a beneficiary does not give you the right to sell the home. The person selling has to have the legal authority from the court. The second big mistake is emptying the house too soon. I touched on this a minute ago, but removing belongings before everything is authorized can lead to family disputes, missing items from the inventory, and even claims against the estate. The third mistake is letting the property expenses slide, failing to keep up with insurance, mortgage payments, or property taxes can seriously damage the estate and reduce the value of the home. And the fourth mistake is assuming a will avoids probate entirely. A will controls how your probate assets are distributed, but it does not automatically keep the estate out of probate. A lot of people are surprised by that one, so I want you to hear it now. Let me give you a real-life example of how this all comes together. Let's say a woman named Maria dies owning a home worth $850,000, and it's in her name only. She leaves a will naming her son as executor. Her son files a petition for probate with the court. Once the court appoints him and grants him authority, he can manage the property. And because he receives IAEA full authority, he can sell the home without a court confirmation hearing as long as he follows the required procedures and notices. The proceeds from the sale go into the estate. The debts and expenses get paid, and the remaining funds are distributed according to Maria's will. That's the whole process, working exactly the way it's designed to. So let's recap what I want you to remember. Probate is a legal process that gives someone the authority to manage your loved one's assets, and you can't skip it just because everyone in the family agrees on what should happen. A family member cannot automatically sell a probate home. The personal representative has a responsibility to protect the property throughout the entire process. Selling authority depends on whether that representative has full or limited IAEA authority, and proper notices may be required before the sale can happen. The sale proceeds belong to the estate until debts and distributions are completed. And finally, a probate experienced real estate professional can help coordinate the property sale while working alongside the attorney and the personal representative. Understanding this process before you start, rather than learning it as you go, is the best way to protect the estate, avoid disputes, and get the sale done properly. One more thing before you go. This video is general information only. It's not legal, tax, or financial advice. I'm Shanty Soerjono, a California probate and trust real estate specialist, not an attorney, and every family's situation is unique. So please talk with a licensed probate attorney about your specific situation before making any decisions. If you'd like help with the real estate side of the process, I offer a free, no-pressure consultation for probate and trust sales. We can talk through your family's situation, answer your questions, and help you understand your options. I'm Shanty Soerjono, and I'm here to help your family through this.